The evidence leaders are suggesting that they must deal with those in respect of which there is no contention or issue around the timing of their delivery, and that the rest will be dealt with in due course. What would you say the problem is with that approach, if I'm capturing what the papers say correctly?
Thanks, Commissioner. I think it is quite clear that the documents have been read, and with that being said, and with that summary, it is in a way towards what the matter is all about. The issue is twofold, Commissioner. Our client received documentation from the Commission as far early as November 2025, and he duly complied with all the requirements in terms of those documentation. And as at December 2025, he received a notification for his appearance on the 20th of January, which at the time there was no problem. However, a day before the 20th, he now receives a notification that he's to appear on the 30th. But he must come back on the 22nd to receive the documentation. Now, on the 22nd, 6 days before the appearance, which is on the Thursday, he now receives a memory stick which contains, according to the evidence leaders, 4,800 pages of documentation that he needs to prepare, and he needs to answer to the Commission in 6 days' time. Given the fact that it was on a Thursday and I was not available, he only managed to consult with me on the 26th, 4 days before the Commission. At that time, we have not even yet opened the documentation, but in meeting with the evidence leader on the 26th, on a Monday, it was then clearly indicated to us that more documentation or more files are still forthcoming by end of business. But we still have to be ready by Friday. Now, at that time, we raised the issue to say it's not going to be possible. There's 4,800 pages that we have to go through. We still have to receive some documentation from you. We are ready. The documentation that he received in December and that he has already made statements to the Commission about, that part we are ready to proceed. But the one that we just received now, 4 days before, we can't. We still have to peruse, we still have to consider. We still have to then consult, because it is not true that when a person has to come and then appear before the Commission, evidence is only limited to what has been given to him. He may have his own independent evidence that we need to source. He may have to be able to consult and corroborate his versions and narrative. We're not going to have time to be able to do that. We endeavored at all costs to print the 4,800 pages. We only completed printing those documents by 2 o'clock the 27th. That will mean we now fully access the documents at 2 o'clock the 27th, 3 days before. And we had to prepare to appear. Now, my client is prepared to appear at all costs. It doesn't matter it's about who or who. But he wants to, when he does that, he should be able to do that proper without prejudicing his own rights. He should be able to substantiate his narrative and his versions. Now, unfortunately, Commissioners, we were since in the last 3 days bogged down by having to make this application. An application for postponement, having to receive the answering, an application to be off camera, having to receive and those type of things. Now, as a result, parallel to all this process, we also have to try to read the 4,800 pages. We are not anywhere near. Now, we also noted the version and the narrative, or the kind of compromise that was made by the evidence leader to say, maybe let's focus on this.
May I just ask this, Mr. Ngwato? You say that you are prepared for the Commission to proceed today in respect of some of the documents. I just want to get an idea of whether there is convergence between you and the evidence leaders on the documents that you are prepared to proceed with or on.
Okay.
Is there convergence there? If there isn't, where's the divergence?
Commissioner, in our application, the purpose of application, we clearly state, for the documentation and representation that we've already made, we are ready to proceed. which is very specific. It refers to the...
Just refer to the convergence and
Yes.
divergence, please, because that still confuses me, because
Okay.
I'm not sure what's what.
So they don't seem to accept it, or they don't accept it. They want the whole full version, the past of last year and the one that was given to us 3 days ago. They want the full-blown aspect. The only compromise they want to make is that on the 3 days one that, or the one that was given to us 3 days ago, can they only now focus on this particular person of interest? And I'm saying that's too dangerous for our client. It is not just about that person. Out of the 4,800 pages, we may have corroborative matters that we need to refer to. And if you are now going to try to now put us only to this 100, as if it's only about this 100, it's also misleading. Because this is a person of interest, and this was not just an independent, isolated, just person. It's a whole concocted group of people that were involved in this. So therefore, it then means that we may have to...
Do you
go
mean
through
concocted, or did you mean some other verb?
Commissioner, what I mean is that it's intertwined and interrelated. It's not just an isolated aspect. It's one person. You don't have just a relationship with just one person that is only concluded there. It's one person that you know through somebody and the other person and the other person. Therefore, it might be that your corroborative information is not only found only in his file, but is found in somebody's file. So we then have to read everything, and not just only that, because the narrative will be very wrong and very misleading and will be very limited. But for our defense, it is important that our client is properly consult, peruse the documentation, consider the documentation, and more importantly, the context in which whatever comments he made, they were made under.
Yes.
So, unfortunately, the evidence leaders are of the view that we can deal with the first part, and then on the second part only deal with this one. And this is where we say no. On the second part, on documents we received 3 days ago, we request to be given time to peruse, consider, and consult. We don't want to come before the commission like what we've seen already on TV, on people coming and appearing before you unprepared, and now having to answer to questions that they were never given an opportunity to. We want to be clear and fair and assist the commission in whatever way, and he's willing to do so, but only if he's just been given a fair chance. These documents specifically are said to have been downloaded from his cell phones. His cell phones were taken from him in October last year by SAPS. Now, they had 4 months with his cell phones to download the documentation, but they give him less than 4 days to prepare what it took them 4 months. But it's not just about the 4 months. The relationship that he had with those people may go 40 years or 4 years down the line. How is he going to be able to deal with that in 4 days?
There were no cell phones, were there? 40 years ago. I'm not sure, maybe there were.
I'm just giving you to say the relationship that he has with these people is a long-term relationship. It goes beyond decades. It's more than 10 years that he probably have known these people. And whatever has been downloaded from his cell phone is not necessarily maybe only from last week. It may go back, and he may have to then give a context on that. Now, they downloaded decades of WhatsApp from his phone. They took 4 months to download it, or to deal with it, or to consider it, or to analyze it, and they want to give him less than 4 days to answer about it. He's not even having these phones. The phones are with them. He does not have any other source to say, how can I refresh my mind? It's not like he's been having his phones all the time, and he's been going through these things all the time. He doesn't have these phones anymore. They are with them. And it may be that some of the information we need may be still in those phones. What if we may need to say, no, let's call back the same phones because you have not downloaded all the information. We need to see some of this information. We don't want to even begin to suggest that some of the information that has been printed, we may say, no, this is not how it is, it's been tampered with. It leaves a lot for us to, it then suggests that we need a lot for us to then go through. And to have to be given 3 days to say, this is 3 days. If you can't deal with these 3 days, or consider going through them over the weekend. It can't be. I'm in a private practice. I have other clients. I have commitments already. And it cannot be presumed that I'll automatically be available to assist this client over the weekend without even the decency of asking me my availability. We indicated on Monday This 4,800 will require time to go through it. Give us the time. They don't even ask us how much time we need. The answer is just no, upfront.
And how much time do you need?
We need 6 days.
Sorry?
6 days.
6 days. Yes, Mr. Ngoto.
So, and that shows an attitude of people who have already concluded, and by any other means, they want to continue with it. And it becomes, Commissioner, a very concerning issue. As in the middle of consultation yesterday, the President made an announcement, media statement, where the same client that has not even testified, his name is there, that there's a prima facie evidence and therefore the SAPS must investigate him. He has not given evidence. The fact that when General Kumalo presented his evidence showed him carrying a bag, that does not mean that he's transporting money. And this now already impacts on him.
I'm not sure what the relevance of that is now, Mr. Ngwato. And effectively, I don't know to what extent you have engaged with the terms of reference of this commission. I will tell you now that the commission actually does have powers to do that. You are not criticizing the president, you are criticizing the commission. Of course, I will be the first to admit and accept that we are not beyond reproach. If we must be criticized, I will welcome that. Freedom of expression, the Constitution itself. I have been a justice of the Constitution, of the Constitutional Court. So I understand you have the right to criticize whoever, but the point of substance is, on my reading of the terms of reference, we are perfectly entitled to do what we did. That referral was made by us, not by the president. So unless you first engage with the terms of reference and tell me why we are not entitled to do what we did in respect of that witness, I think you are going beyond the realms of what you are entitled to traverse.
Thank you, Commissioner. Let me clarify what I mean by that. What I mean by that is that my client has not given any chance, right of response to the
that we have heard, and I think please try to wrap up, because I think now you are getting to the point where you are repeating yourself.
No.
I'm not gagging you. I'm not gagging you.
Yes, I was just saying. I said, Honorable Commissioner, let me clarify what I meant by that. What I meant by that was, and without having to repeat myself, is that he has not been given any right of response by anyone under any circumstances, whether in writing or oral. But such a submission has already been made to the public, and it's quite of great importance to this person because it affects his right. And unfortunately, Commissioner, it may be unsettling and uncomfortable, but it's the truth of what actually happened. And now, when the evidence leaders approach us, in light of these circumstances, when narratives and issues has already been said in the public domain, especially from the office of the president, coming from the high reputable commission of this nature, it is of concern that I want to go and present, and I'm not being given a chance to do so.
Please try to wrap up, Mr. Ngwato.
Thank you,
and
Commissioner.
Please try to focus on the application before us, the application for a postponement.
Just in short and in conclusion, Commissioner, says that my client is prepared and ready to testify about the evidence and the request and the documentation he received in 2025, in which he has since made the written representation to the Commission. That part is okay. The second part of what is required of him to testify about, which is documentation and the bulk of documentation that he received on 3 days before the Commission, he's not ready to do so because he hasn't had enough time to peruse. That's in a nutshell. That part. We're not rejecting everything in totality. It is only the part on documents that he has received 3 days ago.
Thank you, Mr. Ngwato.
Thank you, Commissioner.
Mr.
Mr. Chaskasi, sorry, let me just clarify. Mr. Ngwato, you in paragraph 3.1 of the application, you say this is an application wherein I request order, which order directs the hearing scheduled 30 January with regards to 13 files. So it's the 13 files that you are
Indeed.
concerned about, that you are seeking to be heard later.
Yes, indeed. Those are the 13 files that we received 3 days ago.
Okay. All right.
Thank you.
Thank you. Thank you.
Can I just clarify something? I'm looking at paragraph 4.4 of the founding affidavit. Especially the first 2 sentences on page 7. What I understand the affidavit to be saying there is that your client is ready and prepared to testify on his witness statement that he provided on the 16th of December 2025, and he can do that today. But the 4,800 documents that he received a few days ago, he cannot testify on that because you have not had time to consult with him on those documents. So you need a further 6 days to go through those and to deal with those. But today he can give evidence in chief based on his statement of the 16th of December 2025. Am I understanding you correctly?
100% correct.
Mr. Chaswasi?
Chair, there have been a range of factual assertions made here which are just simply wrong. The contention of 3 days, well, let's start at the beginning. It's not 4,800 pages. There's an evidence bundle in front of you which runs to 849 pages, and there is an annexure bundle with 540 pages. That's a total of 1,389 pages. The memory stick containing all of these documents come from the WhatsApps of the witness. The witness's counsel or attorney complains that he doesn't have his phones. But any of us who have a WhatsApp account know that when you get a new phone, you upload your old WhatsApps if you want to. The fact that his phones were taken away sometime in October by the SAPS doesn't prevent him from accessing his historical WhatsApps. He can access them. We always assumed he would have accessed them. The third factual error is that we haven't had these files since October, whenever they were seized. They were seized by the SAPS. We obtained them from the SAPS only this month. So we haven't had much time with them either, but yet we have managed to work out what we want to ask and answer and have answered in relation to them.
But does that mean the SAPS seized the documents for their own purposes? And then you requested the documents from the SAPS?
We got access to them under notice from the SAPS, under compulsion from the SAPS, but only this month. And there was a lengthy period beforehand over whether we could only ask for materials to be provided to us after they had been downloaded, and I don't know what the SAPS were doing between now and October, but we obtained those materials this month. If I understand Mr. Ngwato correctly, he needs another 6 days. But it's important to have regard to the chronology here. Mr. Nkosi, until earlier this month, was due to appear on the 20th of January.
May we take a short adjournment, and
Sure.
may the evidence leaders and the legal representative please see us outside.